Question 1. In a high-stakes environment where multiple challenges arise in regulating online content, lawmakers must balance free speech protections with restrictions against harmful content. Suppose a government enacts a new law that mandates social media platforms to remove any content deemed offensive within 24 hours or face hefty fines. This law does not define what qualifies as offensive and provides no mechanism for appeal. Based international cyber law principles and free speech doctrines, what is the most likely legal concern with this law? A. Violates the principle of net neutrality by interfering with content providers' operations. B. It could lead to over-censorship and the suppression of legitimate free speech. C. It ensures compliance with global cybersecurity standards, making the internet safer. D. It aligns with GDPR's principles on content moderation and privacy. Answer: B. It could lead to over-censorship and the suppression of legitimate free speech. Explanation: this law raises serious concerns about freedom of expression, a fundamental right protected by legal frameworks such as the First Amendment of the U.S. Constitution and Article 19 of the Universal Declaration of Human Rights. The lack of a clear definition for offensive content creates ambiguity, leading to potential overreach and arbitrary censorship by both the government and private companies. The European Union's Digital Services Act (DSA) and the General Data Protection Regulation (GDPR) emphasize due process and user rights, which this law fails to uphold by not providing an appeal mechanism. Courts have often ruled that overly vague laws on speech are unconstitutional because they lead to chilling effects where individuals and platforms censor more than necessary to avoid penalties. Why other options are incorrect? A. Net neutrality is about ensuring that internet service providers (ISPs) do not discriminate against certain types of data. Content moderation laws do not directly impact neutrality. C. Global cybersecurity standards focus on protecting systems and data, not restricting speech. D. GDPR governs personal data protection, not content moderation policies. Question 2. When implementing backup procedures across various jurisdictions, a multinational cloud storage provider faces conflicting legal obligations regarding data retention. The European Union's General Data Protection Regulation (GDPR) requires that personal data be deleted upon user request, while U.S. laws, such as the Patriot Act, allow government agencies to demand data retention for national security reasons. What is the most legally sound approach for the cloud provider to take in order to comply with both sets of regulations? A. Prioritize U.S. laws or GDPR since national security concerns override privacy rights. B. Delete all user data preemptively to avoid legal conflicts. C. Implement jurisdiction-based data segmentation and separate storage policies per region. D. Only comply with EDR and refuse to store any data for law enforcement agencies. Answer: C. Implement jurisdiction-based data segmentation and separate storage policies per region. Explanation: this issue reflects the conflict of laws in cross-border data management. GDPR Article 17, right to erasure, grants individuals the right to have their data deleted upon request, while U.S. laws like the USAH Act and Cloud Act require companies to provide access to data when requested by law enforcement. The best legal approach is to compartmentalize data based on jurisdiction, meaning European users' data is stored at U.S. centers, where GDPR applies. U.S. users' data is stored in the U.S. where local laws permit law enforcement access. This follows the principle of data sovereignty, ensuring that data stored in each jurisdiction adheres to its respective legal requirements. Many cloud providers, such as Microsoft Azure and others, already implement this method to comply with local legal frameworks while minimizing legal risk. Why other options are incorrect? 8. Prioritizing U.S. law over GDPR would violate EU jurisdictional rules, leading to massive penalties. GDPR Article 83, which allows fines up to €20 million or 4% of global revenue. B. Deleting all user data is not feasible as legal retention obligations exist in various jurisdictions. D. Refusing to cooperate with U.S. law enforcement could lead to sanctions or legal actions under the Cloud Act. Question 3. During an emergency response where multiple areas are impacted by a ransomware attack, a financial institution faces a dilemma. A hacker has encrypted its critical customer data and demands a ransom in cryptocurrency. Paying the ransom would allow the institution to regain access to its data, but it may also violate anti-money laundering (ML) laws. What is the most legally compliant course of action for the institution? A. Pay the ransom to restore operations quickly and avoid legal consequences. B. Contact law enforcement and comply with EMA laws before taking any action. C. Use an untraceable method to pay the hacker to avoid regulatory detection. D. Shut down operations permanently to prevent future cyber attacks. Answer: B. Contact law enforcement and comply with EMA laws before taking any action. Explanation: ransomware attacks create legal and ethical dilemmas, but most jurisdictions prohibit or discourage ransom payments because they fund criminal organizations and potentially violate anti-money laundering (AML) laws. Under the U.S. Treasury Department's Office of Foreign Assets Control (OFAC) guidelines, paying ransom to sanctioned entity can result in severe fines and penalties. Similarly, the UK's National Cybersecurity Centre (SEC) and the European Union Agency for Cybersecurity (ENISA) strongly discourage ransom payments. The best legal approach is to immediately notify law enforcement, e.g., FBI, Europol, or national cybercrime units, and follow compliance frameworks like AML and counter-terrorist financing, C2F regulations, incident reporting laws, GDPR's 72-hour breach notification requirement under Article 33, cybersecurity standards like ISO 27001 and NIST cybersecurity framework. While the options are incorrect, A. Paying the ransom does guarantee data recovery and may violate EMA laws. C. Attempting to pay discreetly does not remove legal liability and may worsen regulatory consequences. D. Shutting down operations is an extreme measure and unnecessary when cyber incident response plans exist. These advanced cyber law questions challenge students to analyze real-world legal conflicts in data protection, cybersecurity, and free speech regulation while reinforcing essential legal principles and compliance obligations. Question 4. In an evolving digital landscape where governments increasingly regulate online financial transactions, cryptocurrency exchanges face complex legal obligations across multiple jurisdictions. Suppose a U.S.-based cryptocurrency exchange operates internationally, allowing users from the European Union, EU, and Asia to trade digital assets. The company recently introduced a new privacy policy that allows it to collect and share customer transaction data with third parties for security purposes without user consent. Based on DDR principles and U.S. financial regulations, what is the most significant legal risk associated with this policy? A. The policy may violate GDPR's requirement for explicit user consent or processing personal data. B. The policy aligns with anti-money laundering (AML) laws and ensures compliance with the U.S. Bank Secrecy Act (BSA). C. The policy strengthens cybersecurity measures and reduces the risk of fraud, making it legally justifiable. D. The policy is necessary for the exchange's compliance with international tax regulations, including FATCA. Answer: A. The policy may violate the GDPR's requirement for explicit user consent when processing personal data. Explanation: under the General Data Protection Regulation (GDPR), personal data, including financial transactions, cannot be collected or shared without explicit user consent unless there is legitimate legal basis. The exchange's policy of sharing data for security purposes without consent could lead to hefty penalties. DDR, Article 83, which allows fines up to €20 million or 4% of global annual revenue. Key legal issues include lack of transparency, Article 5, failure to obtain explicit consent, Article 6, violation of data minimization principles, although AML laws like the U.S. Bank Secrecy Act (BSA) and Financial Action Task Force (FATF) recommendations require financial institutions to monitor transactions. These laws do not override DDR's privacy protections. While our options are incorrect, B. While EMA laws require monitoring, they do not eliminate user consent rights at EDR. C. Enhancing security does not exempt company from privacy laws. D. Tax compliance, e.g., FATCA, justify unauthorized data sharing. Question 5. As artificial intelligence (AI) continues to transform global industries, governments struggle to establish ethical and legal frameworks for its deployment. Suppose an AI-powered hiring platform is used by multinational corporations to screen job applicants. The system automatically filters out resumes based on historical hiring data but has been found to disproportionately reject candidates from certain demographic groups. What is the primary legal concern associated with this AI-driven hiring process? A. The AI system may be engaging in discriminatory practices that violate equal employment laws. B. The AI system improves efficiency, making it a legally acceptable hiring tool. C. The AI system does not require regulation since it is operated by a private company. D. The AI system is exempt from bias concerns because it was designed using objective algorithms. Answer A. The AI system may be engaging in discriminatory practices that violate equal employment laws. Explanation: AI-driven hiring systems that use historical data may reinforce existing biases under laws like Title I of the Civil Rights Act, EU General Data Protection Regulation (GDPR). Article 22. Automated Decision-Making, UK Equality Act 2010. Employers cannot use AI models that lead to discrimination, even if unintentional. Companies must conduct algorithmic audits, ensure fairness, and offer human review mechanisms. Why other options are incorrect? B. Efficiency does not excuse legal violations. C. AI systems in hiring must comply with anti-discrimination laws. D. Even odd algorithms can be biased based on training data. Question 6. With the rise of cyber attacks targeting critical infrastructure, governments worldwide have imposed strict regulations on cybersecurity practices. Suppose a large energy company suffers a ransomware attack that disables power grids across multiple states. The company refuses to disclose the breach, fearing reputational damage. However, under recent cybersecurity laws, companies are required to report such incidents within a specified time frame. What is the most immediate legal obligation for the energy company? A. Report the cyber attack to the appropriate regulatory authorities within the legally mandated time frame. B. Keep the incident confidential to prevent public panic and economic instability. C. Negotiate directly with the attackers to restore services as quickly as possible. D. Refrain from reporting the breach unless customers file a lawsuit. Answer: they report the cyber attack to the appropriate regulatory authorities within the legally mandated time frame. Explanation: cybersecurity regulations such as U.S. Cyber Incident Reporting for Critical Infrastructure Act (CIRSA) 2022, EU Network and Information Security NIST Directive DDPR, Article 33, 72-hour breach notification require companies to report cyber incidents to national cybersecurity agencies promptly. Failure to report can result in legal liability, regulatory fines, and loss of public trust. Why other options are incorrect? Concealing cyber attack violates transparency laws. C. Paying ransomware attackers is discouraged due to OFAC sanctions. D. Reporting laws apply regardless of lawsuits. Question 7. As governments expand digital surveillance programs to combat cybercrime, privacy advocates warn of potential human rights violations. Suppose a new law mandates that all internet service providers ISPs store user browsing history for 5 years and grant law enforcement unrestricted access. What is the primary constitutional or human rights concern with this law? A. It may violate individuals' right to privacy and freedom from warrantless searches. B. It ensures public safety and national security, making it legally justified. C. It aligns with standard business data retention practices. D. It prevents cybercrime by allowing proactive monitoring of all users. Answer: A. It may violate individuals' right to privacy and freedom from warrantless searches. Explanation: this law raises serious legal concerns under Fourth Amendment U.S. protects against unreasonable searches. European Convention on Human Rights, Article 8, right to privacy, GDPR's principle of data minimization. Courts have ruled that mass surveillance programs must have legal safeguards, such as judicial oversight, warrant requirements, user consent mechanisms. Why other options are incorrect? B. National security does not override fundamental rights without due process. C. Business policies differ from government-imposed mass surveillance. D. Blanket monitoring of all users lacks legal proportionality. Question 8. During a critical transition period where existing processes are being replaced with AI-driven automation, an international financial institution is concerned about potential data privacy violations under the European Union's General Data Protection Regulation (GDPR). Which of the following practices would most likely result in non-compliance with EDR? A. Implementing AI models that automatically process customer financial data without explicit consent. B. Providing clear and accessible privacy policy detailing the AI data processing methods. C. Offering customers the option to opt out of automated decision-making that significantly impacts them. D. Establishing Data Protection Officer (DPO) to oversee AI compliance with ED. Answer A. Implementing AI models that automatically process customer financial data without explicit consent. Explanation EDR requires explicit consent for processing sensitive personal data, including financial information under Article 6, Lawfulness of Processing, and Article 22, Automated Decision-Making. AI-driven automation that processes customer data without obtaining clear consent violates GDPR. Conversely, B. Aligns with GDPR's transparency principle Article 12. C. Ensures compliance with the right to opt out of automated decisions Article 22. 3. D. Is required for organizations engaging in large-scale data processing Article 37. Question 9. In a high-stakes environment where multiple challenges arise in digital contract enforcement, a dispute emerges regarding an contract signed using a click-wrap agreement. Which legal principle best determines the enforceability of this agreement? A. The principle that online contracts are inherently unenforceable. B. The presence of clear and unambiguous terms that the user must affirmatively accept. C. The requirement that a physical signature is necessary for a valid contract. D. The assumption that passive browsing of terms implies acceptance. Answer B. The presence of clear and unambiguous terms that the user must affirmatively accept. Explanation. Click-wrap agreements require users to actively click. I agree, making them legally binding under contract law. A is incorrect because online contracts, including click-wrap, are enforceable if they meet contract formation requirements. C is incorrect as electronic signatures. E. Sign Act in the IDAs in the EU hold the same legal weight as physical signatures. D is incorrect because browse wrap agreements where terms are passively posted are often found unenforceable due to lack of affirmative assent. Question 10. While investigating a complicated issue between different jurisdictions, a multinational tech company faces conflicting data localization requirements. Which legal principle best helps resolve jurisdictional conflicts in cross-border data transfers? A. The concept of territorial sovereignty, where only the country of data collection has jurisdiction. B. The principle of comity, where courts recognize and enforce foreign laws when appropriate. C. The supremacy of GDPR, which overrides all conflicting national laws. D. The automatic application of US law in international technology disputes. Answer. B. The principle of comity, where courts recognize and enforce foreign laws when appropriate. Explanation. B is correct as comity allows courts to consider foreign laws in cross-border disputes. Courts may defer to foreign regulations if they do not contradict public policy. A is incorrect because sovereignty does not prevent data processing outside a jurisdiction. C is incorrect because GDPR applies only within the EU but influences other laws. D is incorrect because the US does not have unilateral jurisdiction over global data disputes. Question 11. When developing a solution that must address opposing needs between law enforcement access and user privacy, which legal doctrine plays the most critical role in balancing these interests? A. The doctrine of prior restraint. B. The necessity and proportionality test. C. The absolute right to privacy. D. The exclusionary rule. Answer. B. The necessity and proportionality test. Explanation. B is correct as courts apply necessity and proportionality to determine if law enforcement access to data justifies privacy intrusions. E.g. Carpenter v. as 2018. A is incorrect as prior restraint applies to government censorship, not privacy. C is incorrect because privacy rights are not absolute under laws GDPR and the Fourth Amendment. D is incorrect since exclusionary rule applies to illegally obtained evidence in criminal cases. Question 12. During an emergency response where multiple areas are impacted by a cyber attack on a critical infrastructure system, what legal framework governs state responses to such cyber incidents? A. The Tallinn Manual on Cyber Warfare. B. The Fair Credit Reporting Act of CRA. C. The Lanham Act. D. The Sherman Antitrust Act. Answer. A. The Tallinn Manual on Cyber Warfare. Explanation. A is correct as the Tallinn Manual guides how international law applies to cyber conflicts, including state responses to cyber attacks. B is incorrect as if CRI concerns consumer credit data protection. C is incorrect as the Lanham Act deals with trademarks. D is incorrect as Sherman Antitrust Act addresses anti-competitive behavior, not cyber incidents. Question 13. When implementing backup procedures across various cloud service providers, what is the most significant legal risk organizations face under cloud computing regulations? A. Data sovereignty issues due to conflicting jurisdictional laws. B. The lack of any legal standards for cloud data storage. C. The guaranteed immunity of cloud service providers from liability. D. The prohibition of encryption in cloud storage. Answer: A. Data sovereignty issues due to conflicting jurisdictional laws. Explanation: A is correct because different countries impose localization laws requiring certain data to remain within national borders, e.g., China's cybersecurity law. B is incorrect as cloud computing is regulated at DDEA and ISO 27001 security standards. C is incorrect because cloud providers are liable under responsibility models. D is incorrect as encryption is not prohibited. It is encouraged for data security. Question 14. In a situation where formal requirements conflict with evolving blockchain regulations, which legal issue is most prominent in smart contract enforcement? A. The inability of courts to recognize smart contracts as legally binding. B. The lack of legal frameworks defining contractual obligations for code-based agreements. C. The mandatory requirement that all blockchain transactions be publicly disclosed. D. The prohibition of using cryptocurrencies in smart contracts. Answer: B. The lack of legal frameworks defining contractual obligations for code-based agreements. Explanation: while some jurisdictions recognize smart contracts, e.g., US electronic signatures in Global and National Commerce Act, many lack clear legal definitions. A is incorrect because courts can recognize smart contracts. C is incorrect since private blockchains exist. D is incorrect as cryptocurrencies are legal in many jurisdictions. Question 15. While examining inconsistencies across various units in a multinational corporation's approach to cybersecurity compliance, the legal team discovers that one subsidiary is storing personal data in country with weaker data protection laws. Which of the following best describes the primary legal concern in this scenario? A. Violation of data localization requirements and cross-border data transfer restrictions. B. Lack of cybersecurity framework within the subsidiary. C. The automatic applicability of the parent company's national laws. D. The exemption of corporate subsidiaries from global data protection regulations. Answer: A. Violation of data localization requirements and cross-border data transfer restrictions. Explanation: many countries, e.g., China, Russia, and the EU, have strict data localization laws requiring that certain data be stored domestically. B is incorrect because a subsidiary may have a cybersecurity framework but still violate data transfer laws. C is incorrect as the subsidiary operates under the laws of the country where it's based, not just the parent company's jurisdiction. D is incorrect because subsidiaries must comply with local and international regulations such as GDPR and the Cloud Act. Question 16. During a comprehensive review of a process that needs improvement in digital forensics, law enforcement faces challenges in retrieving encrypted communications from a suspect's device. Which legal principle is most relevant in determining whether authorities could compel the suspect to decrypt the data? A. The Fifth Amendment right against self-incrimination. B. The Fourth Amendment's protection against unlawful searches. C. The doctrine of prior restraint. D. The absolute power of law enforcement to demand decryption. Answer: A. The Fifth Amendment right against self-incrimination. Explanation: in the United States, courts have debated whether compelling a suspect to decrypt data violates the Fifth Amendment, which protects against forced self-incrimination. B is incorrect because the Fourth Amendment protects against unlawful searches, but search warrants can authorize device access. C is incorrect as prior restraint applies to government censorship, not digital forensics. D is incorrect because courts have ruled that blanket decryption demands may be unconstitutional unless specific conditions are met, e.g., foregone conclusion doctrine. Question 17. In a case where multiple parties have different objectives regarding online copyright enforcement, a content creator argues that an online platform should automatically remove infringing content. Which legal framework primarily governs the platform's liability? A. The Digital Millennium Copyright Act, DEA. B. The Communications Decency Act, CDA, Section 230. C. The Sherman Antitrust Act. D. The General Data Protection Regulation, EER. Answer: A. The Digital Millennium Copyright Act, DEA. Explanation: the DSEA establishes the safe harbor provisions shielding online platforms from liability for user-generated content as long as they remove infringing content upon notice. B is incorrect because DEA Section 230 protects platforms from liability for third-party speech but does not apply to copyright claims. C is incorrect as Antitrust Act deals with anti-competitive practices, not copyright enforcement. D is incorrect because DDR relates to privacy, not copyright law. Question 18. During the introduction of new methods where coordination between AI-driven hiring systems and employment laws is required, what is the main legal risk employers face when using AI for candidate selection? A. Potential discrimination claims under employment law. B. The requirement for AI models to be open source. C. The inability of AI to process personal data. D. The prohibition of AI in recruitment processes. Answer A. Potential discrimination claims under employment law. Explanation: AI-driven hiring can lead to bias and violate laws like the Civil Rights Act, Title IX, and the Americans with Disabilities Act (ADA) if not properly designed. B is incorrect because AI models do not have to be open source, but they must comply with ethical AI standards. C is incorrect because AI can process personal data, but must comply. Privacy laws in DDIAPA. D is incorrect as AI is not banned in hiring, but is subject to legal and ethical oversight. Question 19. When implementing new protocols in a shared environment involving cloud-based health records, which regulatory framework applies most directly to ensure data security? A. The Health Insurance Portability and Accountability Act, HIPAA. B. The Fair Use Doctrine. C. The National Labor Relations Act, ERA. D. The Digital Millennium Copyright Act, DAE. Answer A. The Health Insurance Portability and Accountability Act, HIPAA. Explanation: HIPAA mandates security, privacy, and breach notification rules for protected health information stored in the cloud. B is incorrect as fair use doctrine pertains to copyright, not healthcare data. C is incorrect. ERA regulates labor rights, not medical records. D is incorrect because DSEA governs copyright law, not patient data. Question 20. While managing a hybrid approach where timing issues affect software license compliance, what legal principle determines whether a company's use of software license remains valid? A. The terms of the end-user license agreement, EULA. B. The first sale doctrine. C. The implied warranty of merchantability. D. The concept of fair dealing. Answer A. The terms of the end-user license agreement, EULA. Explanation: EULAs dictate how software can be used, including license duration, renewal terms, and restrictions. B is incorrect as first sale doctrine applies to physical copies of software, not digital licenses. C is incorrect because merchantability applies to goods, not software licenses. D is incorrect since fair dealing is a copyright principle, not a software license rule. Question 21. During a major transformation where existing methods of cybersecurity auditing are being automated, which of the following legal issues is most critical? A. Ensuring compliance with data protection laws such as DDR-DPA. B. The lack of legal recognition for cybersecurity standards. C. The automatic immunity of companies from cyber liabilities. D. The requirement to avoid encryption in security audits. Answer A. Ensuring compliance with data protection laws such as GDPR/EPA. Explanation: automated cybersecurity tools must comply EDOE and industry regulations to avoid privacy violations. B is incorrect because many cybersecurity standards ISO 27001 NIST are recognized by law. C is incorrect because companies are liable for data breaches under laws DDR. D. Incorrect as encryption is encouraged in cybersecurity practices. Question 22. When dealing with a complex system that shows occasional failures in online content moderation, the social media company receives complaints about harmful posts that remain visible. Which legal framework primarily governs the platform's liability? A. Section 230 of the Communications Decency Act, CDA. B. The Fair Credit Reporting Act, IFCRA. C. The Digital Millennium Copyright Act, DEA. D. The Electronic Communications Privacy Act, ECPA. Answer A. Section 230 of the Communications Decency Act, CDA. Explanation: Section 230 provides immunity to online platforms for third-party content, allowing them to moderate content without being treated as publishers. B is incorrect because the IFCRA applies to credit reporting agencies, not content moderation. C is incorrect because DSEA deals with copyright, not harmful content. Incorrect since the ECPA protects electronic communications from unauthorized access but does not regulate platform liability. Question 23. During an emergency response where multiple areas are impacted by a cybersecurity breach, which immediate legal obligation does a company have a DDA notify the relevant data protection authority within 72 hours? B. Immediately delete all affected user data. C. Refuse to disclose details of the breach to protect trade secrets. D. Automatically compensate affected users without investigation. Answer A. Notify the relevant data protection authority within 72 hours. Explanation: GDPR requires companies to report breaches within 72 hours if the incident poses a risk to individuals' rights and freedoms. B is incorrect as deleting data could violate evidence preservation laws. C is incorrect because GDPR mandates transparency in data breaches. D is incorrect since compensation depends on investigative findings, not automatic payment. Question 24. In a high-stakes environment where multiple challenges arise in AI-generated content, a court must decide whether AI-created works are eligible for copyright protection. What is the legal stance in most jurisdictions? AI-generated works are not protected because copyright requires human authorship. B. AI-generated works receive full copyright protection like human-created works. C. Copyright laws automatically grant protection to the company that developed the AI. D. AI-generated works are protected only if they meet originality tests. Answer A. AI-generated works are not protected because copyright requires human authorship. Explanation: most jurisdictions, e.g. US, UK, require human authorship for copyright protection. B is incorrect because AI cannot legally be an author. C is incorrect as companies must establish significant human contribution to claim copyright. D is incorrect because originality applies only to human-created works. Question 25. In a situation where formal requirements conflict with cybersecurity best practices, an organization struggles with outdated regulations that do not address modern threats. What is the best legal approach? A. Implement cybersecurity measures while seeking regulatory updates. B. Follow only existing laws, even if they do not address new threats. C. Ignore regulations that do not align with current cybersecurity needs. D. Rely solely on industry guidelines without considering legal requirements. Answer A. Implement cybersecurity measures while seeking regulatory updates. Explanation: best practices evolve faster than laws, so organizations must balance compliance with proactive security. B is incorrect because following outdated laws alone may leave security gaps. C is incorrect since ignoring laws can lead to legal liability. D is incorrect as industry guidelines must align with legal mandates. Question 26. When implementing backup procedures across various locations, a company must comply with data retention laws. Which regulation primarily governs retention of financial records in the U.S.? A. The Sarbanes-Oxley Act, SOX. B. The Children's Online Privacy Protection Act, CUPA. C. The Computer Fraud and Abuse Act, CFA. D. The Fair Use Doctrine. Answer A. The Sarbanes-Oxley Act, SOX. Explanation: SOX requires financial records to be retained for at least 5 years to prevent fraud and ensure accountability. B is incorrect as CUPA protects children's online data, not financial records. C is incorrect because CFA deals with hacking and unauthorized access. D is incorrect since fair use applies to copyrighted content, not data retention. Question 27. While analyzing the root causes of sequential problems in software licensing compliance, a company realizes it has been using open source software in commercial products without proper attribution. What legal risk does this pose? A. Violation of open source license terms leading to potential lawsuits. B. No risk since open source software can always be used freely. C. Criminal liability under wire fraud statutes. D. Automatic conversion of the software into proprietary code. Answer A. Violation of open source license terms leading to potential lawsuits. Explanation: open source licenses, e.g. GPL, require compliance with terms such as attribution or source code disclosure. B is incorrect because not all open source licenses allow unrestricted use. C is incorrect as wire fraud applies to deception, not licensing. D is incorrect because violating a license does not make the software proprietary. Question 28. During a major transformation where existing methods of consumer data collection are being revised, a company wants to comply with the California Consumer Privacy Act (CPA). What is a key requirement? A. Giving consumers the right to opt out of data sales. B. Requiring all customers to consent before any data is collected. C. Automatically deleting all collected data after 30 days. D. Allowing data collection without informing consumers. Answer A. Giving consumers the right to opt out of data sales. Explanation: CPA grants California consumers the right to opt out of data sales and request access to or deletion of their data. B is incorrect because CPA applies mainly to data sales, not general data collection. C is incorrect as there is no 30-day automatic deletion rule. D is incorrect because CPA requires transparency in data collection. Question 29. In a scenario where efficiency decreases across multiple cloud computing environments due to legal compliance issues, what is the primary concern at EDR? A. Data transfer between different countries. B. The physical location of cloud servers. C. The number of users accessing cloud services. D. The price of cloud storage. Answer A. Data transfer between different countries. Explanation: GDPR imposes strict rules on cross-border data transfers, requiring safeguards like standard contractual clause CCS or adequacy decisions. B is incorrect. GDPR focuses on data control, not physical storage. C is incorrect because the number of users does not affect compliance. D is incorrect. DDR does not regulate cloud service. Question 30. While updating traditional approaches where interconnections between devices raise privacy concerns, what legal principle is most relevant? A. Data minimization under privacy laws. B. The right to repair laws. C. The principle of net neutrality. D. The first sale doctrine. Answer A. Data minimization under privacy laws. Explanation: data minimization a DDPA requires organizations to collect only necessary data. B is incorrect because right to repair laws address consumer repairs, not privacy. C is incorrect since net neutrality concerns its practices, not privacy. D is incorrect as first sale doctrine applies to physical goods, not data privacy.